This presentation will give you everything you need to successfully pass your interview, advocacy, and drafting exams. Part 4, Drafting the Contract and Exchange of Contracts, and Part 5, Completion and Post-Completion. Drafting the contract. It is the seller's solicitor who drafts the contract. Once the contract is agreed, the parties will each sign one copy of the contract. When both parties are ready to proceed, the contract will be exchanged, so that the buyer will hold the contract signed by the seller, and the seller will hold the contract signed by the buyer. At exchange of contracts, the date for completion of the purchase is fixed, and the parties have a legally binding agreement. There are two sets of standard conditions used in property transactions. The first is used in residential transactions and incorporates the standard conditions of sale. SCS' currently in its 4th edition. The second is more appropriate to complex commercial transactions and is known as the Standard Commercial Property Conditions SCPC' currently in its 2nd edition. Sometimes the transaction will require express conditions to be included. Adding special conditions to the contract does this. The standard forms provide for this on the back of the contract. The following sections of the contract should be considered. Date. This remains blank until exchange of contracts. Seller. Must be a separate legal entity. Partnerships are not, so the names of the individual partners must be set out here. The seller must have legal title. Buyer. Full names of all the buyers must be set out. Property contract must give clear description. Register title description must reflect the wording in the A property register. And B to cross out the root of title option. Specific encumbrances. The seller has a very limited duty of disclosure. He is only required to disclose latent encumbrances and defects in title. This is due to the common law rule of caveat emptor, let the buyer beware. The seller therefore has no duty to disclose to the buyer patent encumbrances, rights over the property discoverable on inspection, nor physical defects. And B, the seller cannot deliberately mislead the buyer or conceal the problems. Defects in title. If it is not possible to remedy a defect in title, the contract must be varied by an appropriate special condition stating that the buyer will accept such title as the seller has. This is undesirable. Latent encumbrances. An encumbrance is something which burdens the land and may restrict the owner or occupier from using the land in a certain way, or may restrict the ability to sell freely, i.e. consent of a third party may be needed. The seller has a duty to disclose latent hidden encumbrances, but not patent encumbrances such as rights of way. Easements and covenants are examples of encumbrances. Disclosable examples include covenant not to shoot grouse, covenant not to sell alcohol, covenant not to park caravans, easements regarding a right to drainage. The standard conditions of sale deal with the SAT SCS 3.1.2, providing that the sale is subject to encumbrances specified in the contract, encumbrances discoverable by inspection pre-contract, encumbrances the seller does not know and could not reasonably know about, entries made in any public register pre-contract except the land registry, the land charges register, and company's house, so these must be expressly disclosed in the contract. Public requirements, e.g. public rights of way. The commercial standard conditions deal with the SAT SCPC 3.1.2. They vary the residential conditions at Clause D. Full/limited title guarantee. Title guarantee is the guarantee of the seller's quality of title to the property. It should not be confused with the class of title given on registration by the land registry, e.g. title absolute. This is the state's guarantee as to the registered proprietor's interest in the land. The seller may choose to give full title guarantee, limited title guarantee, or no title guarantee. Full title guarantee. This is in effect a guarantee on the part of the seller that the seller has the right to sell the property, and that the property is free from all charges and encumbrances, and other rights exercisable by third parties, other than those it did not and could not reasonably have known about. A buyer would expect an owner-occupier to give full title guarantee. Limited title guarantee. No guarantee by the seller that the property is free from all third-party rights, charges, and encumbrances. Instead, this is replaced by a guarantee that the seller has not since the last disposition for value subjected the property to charges or encumbrances that still exist, nor granted any third-party rights which still exist. Sellers who have little relevant knowledge of the property, such as trustees and personal representative, usually give limited title guarantee. No title guarantee. This is where the seller is giving no title guarantees whatsoever, which means that if there is a difficulty with the title following completion of the sale, the buyer will have no remedy against the seller. Note that under the standard conditions of a sale, unless the contract states otherwise, under SCS 4.6.2 the seller will sell with full title guarantee. There is provision on the front of the standard contract to state expressly which form of guarantee is to apply. Completion date for completion default is 20 days after exchange, but usually varied by agreeing a date in contract SCS 6.1.1 SCPC 8.1.1. Time of day for completion is 2 p.m., but often altered SCS 6.1.2 SCPC 8.1.2. Time is not of the essence as regards the completion date. If a party does not complete on the completion date set out in the contract, then the non-defaulting party may make time of the essence by serving a notice to complete. At that point, the defaulting party will have a further 10 working days within which to complete. Until time is made of the essence, the party's only remedy will be compensation at the contract rate under SCS 7.3. Completion is usually effected by post using the Law Society's Code for completion by post. Contract rate of interest at which compensation is assessed. No need to prove loss, and is designed to deter late completion. Payable by either party at 4% above base rate of bank PLC. Purchase price is the amount payable for the property, as agreed. SDLT is paid only on purchase price, not on the amount apportioned for chattels. Deposit SCS 2.2.1 usually 10% of the total of the purchase price, and the chattel's price. The deposit is either held as stakeholder, which means that it is held for both parties, and can't be released until completion, or agents, for the seller ID it can be paid to the vendor on receipt. This is unpopular with buyers, as if the vendor goes bankrupt the buyer loses his money. Chattels/fixtures. The contract must reference any fixtures being removed by the seller, because fixtures form part of the land. Chattels are presumed to belong to the vendor. Pre-exchange of contracts. Exchange of contracts is the point at which the parties become bound by the terms of the contract. Before exchange, the parties' solicitors must make sure that nothing is outstanding. Buyer solicitor searches and documentation. Check all documents received and results of searches. Raise questions or observations on any issues, and check these have been satisfactorily dealt with. Buyer solicitor survey. Check whether carried out and whether it is satisfactory. Buyer solicitor finance check. Deposit amount has been agreed with seller, and cleared funds are in solicitor's client account or buyer relying on SCS 2.2.5. Check that there hasn't been a reduction in purchase price. Has the buyer's mortgage offer been received? Are the terms and conditions satisfactory? Finally, prepare a draft financial statement to check client will have sufficient funds to complete. Seller's solicitor existing mortgage. Obtain redemption figure from mortgagee and ensure that proceeds from sale will be sufficient to pay off the mortgage. If only part of the property is being sold and the proceeds will not be sufficient to discharge the mortgage, the consent of the mortgagee is needed. Seller's solicitor enquiries and contract. Deal with replies to enquiries raised by buyer, and agree any amendments to contract. Mechanics of exchange. This is usually done over the telephone, but may be by post or in person. With the telephone method, exchange takes place at the point in the telephone conversation when the solicitors agree that exchange has taken place. The Law Society has adopted 3 formula for exchange of contract by telephone. Formula A1. Solicitor holds both contracts and the deposit. Solicitor holding contracts inserts agreed completion date into both contracts. Undertakes to send second contract to other side. Formula B. Both solicitors hold their parties' contracts. Buyer solicitor still has deposit. Buyer solicitor undertakes to send deposit monies, and each solicitor undertakes to send their signed contracts to the other side. Formula C used in a chain of transactions. Effect of exchange. Risk/insurance. The common law position is that the risk for the property passes to the buyer on exchange of contracts. This is varied by the SCS, but maintained by SCPC. If SCS 5.1 is included, the risk for the property remains with the seller. Seller's duty of care. The SCS states that the seller owes a duty of care to the buyer to keep the property in the same state of repair as at exchange of contracts. Occupation by the buyer before completion. This may be to carry out works or take up residence. SCS 5.2 expressly states that such an occupation is to be construed as a license. Death or insolvency. Between exchange and completion, the deceased's personal representatives (PRs) are bound to complete even if the mortgage is revoked. The PRs must obtain a grant of representation before they can sell. Joint tenants. A death certificate must be produced. The interest of the JT passes by way of survivorship to the remaining JT. Death of a tenant in common. If there are still at least two ticks that own the property, as long as payment is made to two trustees, the interests of the deceased which has passed to his estate is overreached. Insolvency. A buyer will only be affected by the bankruptcy of the seller if it has notice of the bankruptcy by an entry being made on the relevant register. If the bankrupt is selling, the trustee in bankruptcy is bound by the sale. If buying, the trustee in bankruptcy has the right to disclaim any contracts it considers onerous. Contract traces under the Professional Code of Conduct Rule 10.06. When the vendor's solicitor is instructed to deal with more than one buyer, he must disclose the existence of a contract trace must be disclosed to all prospective buyers. Immediate written confirmation is required if the disclosure is made by phone or face-to-face. If a seller-client refuses to allow a solicitor to disclose this, the solicitor must refuse to act further. A solicitor must not accept instructions to act for two or more clients in the same transaction where there is a conflict or a significant risk of conflict between the interests of those clients. If solicitor acting for joint buyers, he may not be able to act for both parties until one party must seek independent legal advice with regard to the nature of ownership. JT/TIC. It is essential that you obtain instructions from each proposed buyer. When acting for companies, it's important to ensure that the representative of any corporate client has authority to instruct and to ascertain the extent of such authority. The Code of Conduct generally prevents a solicitor acting for both the buyer and seller in a conveyancing transaction at arm's length, unless both parties are established clients and consent in writing. Solicitors may act for borrower and lender. Obviously, unqualified solicitors may not prepare a contract, transfer, conveyance, lease, or mortgage relating to land for reward. Unqualified solicitors' undertakings may not be enforced. Section 52 LPA 1925 requires that all conveyances of land be made by deed. Buyer solicitor. The standard form TR1 is used for the transfer of both freehold and leasehold registered land. This is usually prepared by the buyer solicitor. Pre-completion. The buyer solicitor also raises standard requisitions. These are not requisitions on title, rather they are a request for completion information that will be necessary to allow completion to run smoothly. This information consists of buyer solicitor finance. The buyer solicitor receives a completion statement from the seller's solicitor. This includes apportionments of ground rent, service charge, and the insurance policy. The buyer solicitor sends a financial statement and bill to the buyer. This sets out the balance required to complete, less any mortgage advance, the outstanding solicitor's fees and disbursements. If the buyer solicitor is acting for the lender on the property, the solicitor has to send the mortgagee a certificate of title certifying that it is good and marketable title. This must be in compliance with Rules 3.16 to 3.22 of the Code of Conduct. Buyer solicitor pre-completion searches. Land Registry Search OS1. This provides the buyer with a priority period of 30 days from the search result, known as the registration gap. Bankruptcy search against buyer, if also acting for lender. Any company searches should also be repeated. The official copy must be less than 12 months old. In unregistered land, the solicitor must carry out central land charges searches against the seller and all previous owners. Seller's solicitor replies to standard requisitions. These are set out in SCS 4.3.1 and SCPC 6.3.1. Includes a form containing an undertaking to discharge the vendor's mortgages. Seller's solicitor finance. Completion statement sent to buyer's solicitor. This sets out the outstanding balance on the purchase price, i.e. purchase price less deposit, plus the price for chattels and any apportionments. Obtain the redemption figure from the seller's mortgagee and ensure that there will be sufficient cleared funds to redeem it. The purchase deed, TR1, must reflect the terms of the contract. To be valid, a deed must clearly state that it is a deed, be signed by the seller in the presence of a witness, and delivered. If the seller is a company, for a company to validly execute a deed, it must be signed by 2 officers, or by company seal. Completion. Completion can either take place in person or by post. The seller's solicitor will hand over the following on completion: deeds, official copies if unregistered land. Purchase deed TR1. Any planning permissions granted. Any buildings regulations granted. Restrictive covenant indemnity insurance, if so obtained. An undertaking to discharge the mortgage and send a receipt at DS1 or end. In his replies to the standard requisitions on title, the seller's solicitor will have undertaken to discharge any mortgages/charges attached to the property, usually out of completion monies. Once this is done, he will forward a receipt at discharge of seller's mortgage, DS1, or a copy of the notice of confirmation from the lender that an electronic notice of discharge and has been sent to the land registry to the buyer's solicitor. Both of these forms are simply standard wordings promising to discharge the mortgage. The buyer's solicitor will then check the epitome or abstract to ensure that the documentation corresponds with the official copies/photocopies he received prior to completion. Pay completion monies usually by CHAPS. Post-completion. Seller's solicitor reports to clients that completion has taken place and they can release the key. Discharge the mortgage. This should be done on the same day as completion. Then forward the DS1 or end to the buyer solicitor. Reassign any life policy account to seller for balance of proceeds of sale. Buyer solicitor reports to clients that completion has taken place and they can move in. Date the purchase and mortgage deed. Pay stamp duty land tax within 30 days. Register the conveyance pursuant to LRA 2002. This needs to be within the priority period. Notice of assignment. Custody of the title documents.